Hi, my name is Nikki Matthews, and I'm a California registered tax preparer and bookkeeper at the Lake Arrowhead office of Smith, Marion & Company. I'm going to talk today about the Healthy Workplaces, Healthy Families Act of 2014. This act amends and adds to California law to provide a minimum amount of paid sick days to California employees. California Assembly Bill 1522 was signed into law September 10, 2014 by Governor Jerry Brown and takes effect July 1, 2015. The new law covers employees working in California for 30 days or more within a year. And each reference to a year means a calendar year, 12-month period, or year of employment. In other words, a year means any 12 consecutive calendar months. The law provides at least 1 hour of paid sick leave for every 30 hours worked, up to at least 24 hours per year for each eligible employee. So, although 1 hour accrued for every 30 hours worked may add up to more than 24 hours in a year, the employer is only required to provide up to 24 hours or 3 days. Conversely, an employer may certainly offer more than 3 days paid sick leave, but not less than 1 hour for every 30 hours worked. This benefit is available to all full-time, part-time, temporary, and exempt employees who work in California for 30 or more hours within a year from employment. There are exceptions to the employee types covered, such as employees covered by a collective bargaining agreement, employees of in-home support services, and certain air carrier employees. But otherwise, this bill affects all employers, even if there is only one employee. This law also covers out-of-state employers who have California employees. Although many employers already offer paid time off benefits to their employees, about 40% of California employees have no paid sick leave benefits. Paid sick leave will help with the overall public health of Californians by allowing employees time off to take care of their health and their family's health. Employees will be less likely to come to work sick if they have paid time off. In 2006, San Francisco became the first county in the nation to require employers to provide paid sick leave for all employees within the county. And with Governor Jerry Brown's signature of AB 1522, California has become the second state to pass such a law after Connecticut approved a similar statute in 2011. Mandatory paid sick leave legislation is pending in at least 20 other states. This new mandatory paid sick leave for eligible employees does not replace more generous paid time off benefits that an employer may already offer. It's just ensuring that all employees in California are provided at least some paid sick leave. So when does an employer have to start offering paid sick leave? The new law takes effect July 1st, 2015. The first requirement is that employees have worked 30 days or more in California within a year from their employment date. Employees can meet the 30-day employment requirement before July 1st, 2015. Employees begin accruing paid sick leave at the commencement of employment or July 1st, 2015, whichever is later. For example, if an employee has been employed several months or years without benefits, his new paid sick leave benefit begins accruing on July 1st, 2015. If an employee is hired after July 1st, 2015, his benefit begins accruing at his hire date. Employees must have been employed for 90 days before they can begin using accrued paid sick leave. So, although an employee may begin accruing this benefit at July 1st, 2015, he cannot start using it until 90 days into his employment. After 90 days, employees can use paid sick leave days as they are accrued, and although the new law does not require employers to pay out paid sick leave until that 90th day of employment, an employer certainly can elect to advance sick leave pay to an employee before it has been accrued. So how much paid sick leave does an employer have to offer? An employer will accrue 1 hour paid sick leave for every 30 hours worked. An eligible employee, meaning one that has worked in California for at least 30 days and working 40 hours per week, would accrue 1.33 hours of paid sick leave. That's 40 hours divided by 30 equals 1.33 hours paid sick leave per week. A full-time employee working 2,080 hours would accrue almost 9 days paid sick leave. However, the new law allows employers to cap accrual of paid sick leave at 48 hours or 6 days per year. So although the formula of 1 hour paid sick leave for every 30 hours worked adds up to nearly 9 days for a full-time employee, an employer may elect to limit that amount to just 6 days. Additionally, AB 1522 allows employers to cap use of paid sick leave at 24 hours or 3 days per year. The next question is undoubtedly, how can an employer cap accrual at 6 days per year but cap use at 3 days per year? The logic is that an employee can accrue more sick days than they can use in a year in order to allow employees available sick leave at the beginning of the new year. And the key here is that it banks up to 3 additional paid sick leave days to be available on the first day of the new year, whether that be January 1st or the start of some other 12-month period. So what else do I need to know? An employer may set a reasonable minimum increment not to exceed 2 hours for use of paid sick leave. In other words, an employee can request and be allowed a partial paid sick day of a minimum 2 hours. An employer cannot make the employee take the benefit for, say, 4 hours or an entire day if he just needs to visit the dentist. 2 hours is the minimum allowable increment an employee can use. Also, employers are not required to pay out accrued paid sick leave upon employee termination. And this is unlike separate paid time off plans that do require PTO payout at separation. Former employees who are rehired within 1 year regain their previously unused accrued paid sick leave. If paid sick days are unlawfully withheld, the employer may be liable for the greater of the dollar amount of the paid sick days multiplied by 3, or $250. The aggregate maximum penalty is $4,000. So an employee earning $100 a day who asks for 3 paid sick leave days and is denied it can be awarded 3 times that amount, or at least $250. In this case, $100 per day times 3 days equals $300, multiplied by 3 equals $900. 900 is more than $250, so the employee would be awarded $900. Does this law only cover an employee who is sick? An additional provision of this law is that it provides for paid sick time for the employee and time to care for the employee's family members, including a child, a parent, a spouse, or a registered domestic partner, a grandparent, a grandchild, or a sibling. That's a pretty broad range of family members for which an employee can use his paid sick leave benefit. The law also offers a pretty broad list of acceptable reasons to use paid sick leave. Paid sick leave can be used for the employee or the employee's family members' diagnosis, care, or treatment of an existing health condition. Paid sick leave can also be used for the employee or employee's family members' preventative care, such as physicals, flu shots, and dentist visits. Paid sick leave can also be used in relation to an employee if he or she is a victim of domestic assault, sexual violence, or stalking. And this could be time off for counseling or even just safe time away from a dangerous situation. How does the employer report this benefit to employees? Each workplace must display a poster containing the information and which is available from the Labor Commissioner. The poster must be placed in a conspicuous place where employees will see it and can refer to it. The employer must provide written notice of this benefit at time of hire. And I believe the poster itself would suffice for this requirement. It's an 8.5 by 11-inch page. The employer must provide each employee written notice of paid sick leave available on either the employee's itemized wage stub or in a separate writing provided on each payday with the employee's wage payment. So to recap, how does it all work? The California employee on or after July 1st, 2015 has been employed 30 days or more within 1 year of their hire date. The employee begins accruing the benefit at either their hire date or July 1st, 2015, whichever is later. The employee earns 1 hour for every 30 hours worked. The employee can begin using paid sick leave days upon 90 days of employment. And the accrual resets each year of employment, calendar year, or some other 12-month basis. Wow, that seems like a lot to keep track of. In lieu of tracking 1 hour paid sick leave earned for every 30 hours worked, an employer may elect to use a lump sum 3 days of paid sick leave per year, whether that's a calendar year, anniversary year, or some other 12-month basis. Under this alternative method, an employer does not need to keep track of accruals or provide carryover of unused sick leave. That's important. However, the lump sum 3 days of paid sick leave must be available at the beginning of the next year as well. And the employer must still track and provide employees written notice of usage and available hours. What about this first benefit year starting mid-2015? I couldn't find specific language about this question in the law itself, but upon advice from the Department of Labor Standards Enforcement, it seems it can be interpreted that from July 1st, 2015 to December 31st, 2015, an employer opting to use a calendar year method and the minimum 24-hour paid sick leave could prorate the minimum 24 hours lump sum in half to 12 hours for the first 6 months of this new law's implementation. After that, beginning January 1st, 2016, an employer using the calendar year and the alternative advance lump sum of paid sick leave would provide the full 24 hours at the beginning of each new calendar year. To recap, the rules for compliance of the Healthy Workplaces, Healthy Families Act of 2014 are to display the poster on paid sick leave where employees can easily read it, provide written notice of paid sick leave information to each employee upon hire, provide an accrual of 1 hour paid sick leave for every 30 hours worked, or at least 3 days per year, allow eligible employees to use accrued paid sick leave upon request, provide written notice of available paid sick leave with each paycheck, and to keep records of paid sick leave accrued and used for 3 years. Thank you for listening to my web video. If you have questions, please feel free to contact Smith, Marion & Company.